if you are carrying a firearm right now, or if you're even just, thinking about getting one, you probably assume you're prepared to defend yourself.
Right. People assume that all the time.
Yeah, but today we're looking at this incredibly eye-opening article that is going to completely shatter what you think the phrase "stand your ground" actually means.
It really is a massive wake-up call.
It is. So our mission for this deep dive is to unpack this blunt article from Valortech, which is a Florida firearms training academy.
Yeah, and it's written by an instructor named Herfel, who has like 30 years of experience in law enforcement and firearms education.
Wow, 30 years. So he knows his stuff.
Oh, absolutely. And his premise is terrifyingly simple, honestly. He argues there is a massive, dangerous gap between legally carrying a concealed weapon and actually understanding self-defense law.
Okay, let's unpack this, because that distinction, between just possessing the tool and actually understanding the legal threshold for using it, that seems like the quickest way to end up in a prison cell.
Yeah, 100%. The foundation of that gap starts with just the raw legal allowance to carry. Florida, like a lot of states now, allows eligible individuals to carry concealed firearms.
Right, the permitless carry laws.
Exactly. But Herfel points out something crucial about the statutory requirements. They completely omit the provision that used to require applicants to, demonstrate actual firearm competence.
Oh, wow. So you don't even have to prove you can shoot.
No. The state basically just asks if you're legally allowed to own the tool. But it doesn't require you to prove you know how to operate it or when to use it, or, most importantly, how to avoid a deadly confrontation in the first place.
So possession is just entirely divorced from preparedness.
Completely divorced.
So if the state isn't testing your knowledge of the law before you carry, what is the actual legal threshold you are expected to just, inherently know?
The author boils the entire legal framework down to 3 critical words. And every armed citizen must memorize these.
Okay, what are they?
Reasonable, necessary, imminent.
Reasonable, necessary, imminent. Okay.
Yeah, and these aren't just like polite suggestions. They are the literal mechanical gears of Florida Statute 7776.012.
Right.
The law dictates that deadly force may be justified only when a person reasonably believes it is necessary to prevent imminent death or great bodily harm.
Or the imminent commission of a forcible felony.
Exactly.
I want to break down the mechanics of those words, starting with imminent, because it implies a ticking clock, right? Like, it isn't a threat that might happen tomorrow.
No, not at all.
Or even a threat that happened 10 minutes ago.
Precisely. The law views imminent as this very narrow window of time that opens and closes instantly. The threat has to be happening in that exact millisecond.
So if the clock hasn't started yet...
Right, or if the clock has already stopped, your legal justification to use force just does not exist.
Wow. Okay, and then you add the word necessary.
Yeah. Did you have any other option? Was pulling the trigger the absolute last resort to stop that ticking clock?
And finally, reasonable, which feels like the trickiest one.
It is. It's the most dangerous word for someone who doesn't understand the law. Because reasonable isn't determined by your own adrenaline-fueled brain in the middle of a fight.
Right, you might think you're being reasonable when you're terrified.
Exactly. But it's actually determined months later in a sterile courtroom by a jury of 12 strangers. They are the ones deciding if a normal, prudent person would have felt the same way you did.
Which brings us to the cultural elephant in the room here. Stand your ground.
Oh, yeah. This is where it gets messy.
Because the law states that if you are acting lawfully and you're in a place you have a right to be, you have no duty to retreat. But doesn't a slogan like "stand your ground" actively mislead people?
Oh, it absolutely does.
I mean, it almost sounds like a cultural mandate. Like, it tricks people into thinking they must stay in a heated, screaming argument over, like, a parking space to defend their honor.
Yeah, like they're surrendering their constitutional rights if they walk away. What's fascinating here is how the gun counter mythology and the sort of social media bravado completely distort the legal reality. The author highlights how incredibly dangerous this interpretation is.
Right, because the statute simply removes the legal requirement to retreat.
Yes, it does not outlaw common sense. Having no legal duty to retreat doesn't mean that retreating is weak or cowardly or tactically foolish.
I love how the author puts it. He says a holster isn't a law degree.
Yeah, that's a great line.
It makes total sense. Like, buying a high-end sports car doesn't magically make you a professional stunt driver just because you have the keys.
Right.
The tool doesn't grant you the talent or the reflexes or the judgment to use it wisely. If your car can go 200 miles an hour, you still don't drive it that fast through a school zone just because you technically can.
Building on that sports car analogy, a mature driver knows when to brake. Just as a mature armed citizen understands the difference between being legally permitted to stay in a location and being tactically smart enough to just leave an escalating situation.
Right. Training doctrines universally agree that an avoidable situation should never be allowed to escalate.
Never. If you choose to plant your feet in an avoidable argument just to prove a point, you might technically be standing your ground, but you're also volunteering to become a case study in a homicide trial.
That physical reality of the trigger, the fact that you have to consciously choose to press it, leads us into a massive problem with how people view their own responsibility.
It really does.
Because if you can't rely on a bumper sticker slogan to protect you, who actually bears the weight of the law when a weapon is fired?
Well, the author anchors this whole concept by looking at the fatal shooting on the set of the movie Rust, the one involving Alec Baldwin.
Right, the movie set tragedy.
Yeah. This case forces us to look at the concept of culpable negligence under Florida law. It's the mechanism used to prosecute someone when they aren't necessarily intending to commit murder, but their actions are so reckless they cause a tragedy anyway.
Okay, so what defines culpable negligence?
It requires conduct that shows a gross, flagrant disregard for human life or safety.
But wait, the criminal case against Alec Baldwin was dismissed. Doesn't that suggest the legal system basically forgave his handling of the weapon?
It is vital to understand why it was dismissed, though. The case was dismissed with prejudice because the court found that prosecutors committed a severe procedural error. They withheld evidence from the defense.
Oh, right. So it was a penalty against the prosecution.
Exactly. The dismissal was a penalty against the state's conduct. It was not an exoneration of the actor's firearm handling. A jury never actually determined that pointing a gun and pulling the trigger without personally checking it was a legally responsible act.
I have to push back on the reality of that situation, though, just examining human nature.
Sure, go ahead.
If a literal expert, like an armorer whose entire professional job is safety, hands you a prop and explicitly tells you it is safe, isn't it instinctual to trust them? Why should the person holding the tool bear the ultimate legal burden if they were lied to by an expert?
I mean, it is a natural instinct to defer to authority, sure. But the legal and physical reality of a firearm cannot be delegated. A firearm is a mechanical device governed by physics. And physics does not care about movie cameras.
Right.
It doesn't care about union contracts or who signed a safety checklist on a clipboard. The inescapable truth the author presents is that a bullet belongs to whoever launches it.
Whoever launches it. Wow.
Yeah, when you press the trigger, you become the launch pad. You cannot outsource the liability of where that projectile travels.
So the law demands that you verify the safety yourself every single time.
Without exception. Think about it. If you're standing in your living room and a stranger hands you a gun, tells you it's unloaded, and asks you to point it at your friend's chest and pull the trigger, you would never do it.
No, of course not. You'd check it yourself or you'd just refuse.
Right. The author's point is that the environment, whether it's a living room or a multi-million-dollar film set, does not alter the fundamental law of responsibility.
The bullet belongs to whoever launches it. That is a really heavy concept to carry around.
It is.
So if the responsibility rests entirely, 100%, on the individual holding the gun, what happens when human psychology overrides logic?
That is where things go horribly wrong.
Right, because when adrenaline and anger enter the chat, all that careful reasoning about imminent and necessary usually just flies out the window.
That surge of adrenaline is exactly what causes the most preventable, horrific tragedies.
Oh.
The article examines this chilling case from February 2021 in Pennsylvania to illustrate this psychological failure.
What happened there?
It involved a long-running neighborhood dispute that finally erupted into extreme violence over something entirely mundane: snow disposal.
A legal argument over shoveling snow.
Yes, a husband and wife were shot and killed in the street, and the shooter subsequently took his own life.
Oh my God.
Yeah, 3 people are dead because of insults, rising anger, and a complete catastrophic inability for anyone involved to simply disengage, turn around, and go inside their houses.
I mean, we've all gotten petty in an argument with a neighbor. Maybe it's over loud music or where a fence is placed. But bringing a firearm into a petty argument is like bringing a lit match into a fireworks factory.
Yes, perfect analogy.
It exponentially raises the consequences of just a momentary emotional failure. You're risking everything you have, your freedom, your life, your family's future, on a hand you can't even see.
If we connect this to the bigger picture, the brutal lesson here is about controlling variables.
Hmm.
You cannot control the stranger you're arguing with. You don't know what cards they hold.
Right, you have no idea.
You don't know if they're secretly armed, if they're intoxicated, if they're deeply unstable, or if they're actively suicidal and just looking for an excuse to end it all. The
Yeah.
only variable you have absolute control over is your own availability.
Meaning you control whether you stick around to see how the hand plays out.
Yes.
Yeah.
The author emphasizes that walking away from an insult does not mean the other person won the argument. It means you maintain control of your ego. It means your family doesn't have to identify your body at the morgue, and you don't have to sit in a defendant's chair for a decade simply because you felt the psychological need to have the final word about where snow was shoveled.
The takeaway from the article is razor sharp on this. If carrying a firearm makes you more willing to argue with people, you are not prepared to carry one.
Not at all.
You are merely armed. And being merely armed is a huge liability.
Definitely.
But let's look at what happens when that psychological control actually fails. A trigger is pulled. Someone is shot. What is the actual mechanism of the legal aftermath? What happens in the seconds and then the years after the smoke clears?
Surviving the physical confrontation on the street is only the first half of the ordeal. Then you have to survive the justice system. To explain the mechanics of the courtroom, the author neutrally reviews two really famous cases.
Okay, which ones?
The first is the Kyle Rittenhouse case in Kenosha, where he was ultimately acquitted of all criminal charges by a jury who accepted his claim of self-defense.
But the author warns against looking at an acquittal as a victory, right?
Yes, the warning is that an acquittal is a legal result. It is not a tactical training doctrine you should try to emulate. In Florida, under Statute 776.041, the legal analysis doesn't just look at the millisecond the trigger is pulled. It hits the rewind button.
Okay, so it looks at the whole picture.
Exactly. The law scrutinizes your conduct before the shooting. Did you provoke the confrontation? Were you engaged in a forcible felony?
And if you were?
If the law determines you were the initial aggressor, you might actually be required to exhaust every single reasonable means of escape before your right to claim self-defense is even restored.
So the law analyzes the entire timeline. Words matter. Forward movement matter.
Every step, every word, and every gesture. And in modern society, you have to expect that every second of that timeline is being recorded from 3 different angles.
That's so true. Everyone has a camera.
The author asks a vital question. Why voluntarily place yourself in the middle of a predictable riot or a violent environment unless you have a strict legal duty or a professional mission to be there?
Right.
Even with a full acquittal, the mechanism of the trial destroys your life. You don't get the money you spent on lawyers back, you don't get your reputation back, and you definitely don't get your peace of mind back.
Here's where it gets really interesting, because sometimes the timeline of violence happens incredibly fast. The author brings up the Michael Drejka case, which was a dispute over a disabled parking space in Florida.
Yes, a very tragic case.
It ended with Drejka receiving a 20-year manslaughter sentence. But looking at the facts of that specific incident, I have a genuine question. Drejka was violently physically pushed to the pavement by a man named Marquise McLaughlin,
He was.
and being violently shoved to the concrete by a larger person can cause severe trauma. Doesn't being physically attacked automatically justify drawing a weapon and defending yourself?
See, that assumption is the exact trap the author is warning against. Yes, Drejka was attacked. Yes, being driven to the pavement can cause serious bodily harm. But the law does not grant you a lifetime subscription to self-defense the moment you are touched.
A lifetime subscription. Wow.
The author breaks down the timeline, which they call the 11-second rule. The entire event, from the physical shove to the lethal shot, took roughly 11 seconds.
So what is the mechanism that turned a physical attack on Drejka into a 20-year prison sentence for him?
The mechanism is the ticking clock of the word imminent that we discussed earlier. The legal justification to use deadly force must exist at the absolute exact moment the trigger is pressed.
Right, the millisecond.
Exactly. Surveillance video and eyewitness testimony showed that after the initial shove, McLaughlin saw the firearm and began backing away. The threat was retreating.
So the clock stopped. The window of imminent danger closed.
Yes. The second the imminent threat stops advancing, the legal shield of self-defense evaporates. A prior attack does not give you an open-ended voucher to shoot someone.
The jury had to look at the exact fraction of a second the gun was fired.
And they had to decide, was this shot defensive to stop an ongoing attack, or was it retaliatory to punish someone for an attack that had already concluded?
And the psychological shift from defense to punishment is where Drejka doomed himself, especially with his mouth.
Post-incident statements are a massive trap. Drejka reportedly made comments to law enforcement, implying that McLaughlin needed to face consequences for pushing him.
Oh, wow. You can't say that.
No. He essentially handed the prosecutors the motive on a silver platter. He told them he was acting as a punisher, not a protector. The author notes a grim reality here.
What's that?
The gun might be completely silent after the final shot, but the shooter usually isn't. Your spontaneous comments, your past social media posts, your recorded jailhouse phone calls, the legal mechanism vacuums all of it up as evidence of your state of mind.
That confusion between protecting your life versus protecting your pride is lethal, and it bleeds perfectly into another dangerous misconception: the confusion between protecting a human life and protecting inanimate property.
Oh, absolutely. The author turns to the McCloskey incident in St. Louis to illustrate how deeply misunderstood property defense laws are.
Right. We all saw the images of Mark and Patricia McCloskey standing outside their massive home with firearms as demonstrators walked past.
Yeah, and people quickly projected their own politics onto those images, viewing them either as heroic defenders of the castle or unhinged aggressors. But the justice system operates on precise facts, not political narratives.
So how does the mechanism of the law, specifically something like Florida Statute 7776.031, actually weigh property against human life?
The legal system is structurally designed to preserve human life as the ultimate currency. A piece of property can be replaced. A human cannot. Therefore, the statute generally permits the use of non-deadly force if it is reasonably necessary to terminate a simple trespass. But the moment you introduce deadly force like pointing a loaded firearm, the legal threshold skyrockets.
Right, because now a life is on the line.
Deadly force is strictly permitted only when you reasonably believe it is necessary to prevent the imminent commission of a forcible felony, like a violent home invasion.
The way the author writes about this strips away all the macho fantasy of, like, defending the perimeter. They state very clearly, trespassing is not a death sentence.
No, it's not.
Your lawn is not worth a human life. Your decorative gate is not worth a human life. A firearm is a lethal tool. It is not an expensive no trespassing sign that you wave at people walking on your grass.
And while Florida possesses a very strong home protection presumption, often called the Castle Doctrine, the mechanism of that law is specific. It generally applies when someone is unlawfully and forcefully attempting to enter a dwelling, a residence, or an occupied vehicle.
So not just the front lawn.
Right. A group of people crossing a property boundary line or standing on a private street does not automatically trigger the same legal presumption as a person violently kicking in your front door with a crowbar. There must be an objectively reasonable belief of imminent death or great bodily harm to justify a lethal threat.
Which leads us to the ultimate illusion in all of this, the illusion of legal immunity. I hear people talk about Florida's stand-your-ground immunity provision as if it is a literal get-out-of-jail-free card from a monopoly board.
Oh, people think that all the time.
They seem to think they can just pull a trigger, hand the responding officers a laminated card with statute 776.032 printed on it, and the cops will just nod, apologize for the interruption, and leave them alone.
The author aggressively dismantles that fantasy. This raises an important question. What does immunity actually look like in practice?
Yeah, what does it look like?
It looks like a grueling, terrifying grind through the legal system. Stand your ground does not mean the police won't investigate you. It absolutely does not mean they won't arrest you.
So it's not a magic shield.
Not at all. And it does not protect you from massive, life-altering attorney fees or the threat of civil litigation from the deceased's family.
So what is the actual mechanism of getting that immunity? What happens after the arrest?
The key word in the statute is justified. If your use of force is ultimately found to be legally justified, you may receive statutory protection from prosecution. But you have to prove that justification through a legal gauntlet.
Wow.
Law enforcement will arrest you if they have probable cause to believe the shooting was unlawful.
Yeah.
You will likely be booked, fingerprinted, and sit in a jail cell.
That's terrifying.
You'll have to post bond. You'll have to hire an attorney at hundreds of dollars an hour and then litigate your immunity claim during a complex pretrial hearing that might not happen for months or even years.
So the process itself is the punishment.
Exactly.
If the legal stakes, the financial stakes, and the personal stakes are this incredibly high, why on earth do so many firearms training courses ignore all of this? Why are academies handing out certificates based entirely on how fast someone can draw from a holster?
Or how tight their bullet groupings are on a piece of cardboard, right?
Right. Why aren't they teaching the psychology of restraint and the mechanics of de-escalation?
Because it is immensely easier to teach a physical mechanic than a psychological one.
Oh, that makes sense.
Teaching someone to align sights and press a trigger on a static, non-threatening paper target takes a few hours. Teaching someone the emotional control required to de-escalate a screaming match or the humility required to walk away from an insult while carrying a lethal weapon takes profound discipline.
The author really criticizes the industry for churning out people who can hit a bullseye but have absolutely no ability to identify when a lawful target ceases to exist.
Yeah, because that is not preparedness. That is just armed ignorance.
So what does this all mean? Bringing all of this together, the ultimate takeaway from this Valortech article is a complete paradigm shift in how we need to view self-defense. Carrying a firearm shouldn't inflate your ego, it should drastically humble you.
The standard for armed citizens must be higher. The true test of responsibility isn't your draw speed under stress. It's your awareness.
Right.
It is your observational skills. It is your absolute willingness to leave an argument. The best defensive shooting is the one you successfully avoided because you saw it coming and walked the other way. You have to recognize every single moment when you must not fire.
If you choose to carry, you own that choice. You own the decision to escalate, and you own the decision to walk away.
Every single time.
And if you ever pull the trigger, you own every single round that leaves that barrel, along with the physics, the laws, and the human consequences that follow it.
It is an immense, life-altering responsibility. It requires an understanding that goes far beyond reciting a political slogan about standing your ground.
It really does. And it leaves me thinking about a terrifying variable that builds right off this article's focus on the word reasonable.
Okay, what's that?
Well, the law requires a reasonable belief of an imminent threat. But we are living in a society that is growing more digitally connected, more anxious, and more eager to escalate and film every minor dispute for social media clout.
That's definitely true.
If our collective baseline anxiety goes up, how will a jury's definition of a reasonable threat shift? 10 years from now, does our legal threshold for pulling a trigger terrifyingly go down just because everyone feels more threatened by default?
Wow. That is an unsettling but essential question for you to ponder regarding the future of self-defense.
It's a heavy question to consider the next time you see a parking lot argument pop up on your timeline. Thanks for joining us on this deep dive. Stay curious, stay informed, and we'll catch you on the next one.